Starting off with the introduction, it is important to note that a good essay doesn't go straight into addressing or answering the question, as we must first develop our essays properly so that the essay as a whole will bear some sense of coherence. Because the chapter in question concerns the second part of the A2 tort law syllabus, i.e. private nuisance and Rounds and Fletcher, we should therefore briefly define and explain the tort of nuisance with a focus on private nuisance. This is where we will be briefly introducing what the tort of private nuisance is and how it sets out to protect the right to use and enjoy land without the interference from others. From here, we can connect our discussion to the core focus of the question, i.e. briefly introducing the characters as well as the main issues in relation to the discussion of the tort of private nuisance. Now that we are done with the brief introduction of the tort of nuisance as well as the issues in the scenario, we should then endeavor to state our objective for the essay. The objective comes in the form of a thesis statement which must address the question, or at least the focus of the question. It is good to have a thesis statement, as this will give the examiner a clear insight of where we are going with our essay, and also to keep us from digressing in our discussion and to ensure that we remain close to what the question is asking us to focus on. With this in mind, we will briefly explain that before we can advise if Zach has any rights against ABC Rails, we will need to go through the common law principles to establish the tort of private nuisance and apply it to the issues in the scenario. While doing so, we will have to critically consider the many aspects of the principles of private nuisance as well as the finer points of the issues itself within the scenario to decide if there is actually any nuisance found in any of the issues and how Zach can claim anything from ABC Rails. As much as we can, the flow of our essay should be as close as possible to the flow of the events that happen in the scenario, so that the overall essay has some coherence. Point 1 of the essay should address the issue of the railway track and the electrical power lines to allow the use of high-speed trains, which has increased capacity and reduced journey times for passengers. This could possibly mean that the train is bigger and faster than the previous one, that it could cause Zach the kind of nuisance that he has never experienced before in that area. It should be noted that the issue with who can sue and who can be sued shouldn't be an issue here, but we should just briefly highlight that Zach should have an interest in the land for which is affected by the nuisance, while ABC Rail is legally occupying the land for which the railway tracks and the power lines are built, in which the nuisance is coming from. Now, to relate this to the tort of private nuisance, we should discuss the requirements to establish private nuisance, i.e., for there to be any claim for private nuisance, there must be an unreasonable interference with another's use or enjoyment of land, which may or may not amount to certain damage. The focus now should be shifted to the terms interference, unreasonableness, and damage. Firstly, interference simply means that there must be some form of disturbance which must be sufficient enough to cause the claimant not to enjoy the use of the claimant's land. In addition to that, it must also be an indirect cause that is due to a continuing state of affairs rather than a one-off incident. Interference can be caused by a lot of things, whether it be a physical invasion of things such as water or something which is as intangible as noise. Based on the facts, the noise from the high-speed train can definitely amount to an interference. However, it should also be noted that what that disturbance interferes with is also important for it to be considered a nuisance. This is important because if that disturbance only interferes with recreational facilities or things of delight, it might not actually amount to nuisance. And since, on the facts, it affects both Zach's recording equipment and internet signal, it may be considered as things of delight. For the recording equipment, it is possible for us to assume that it is used for work, while the internet signal could be used for both work and recreation. Because the facts are silent on this, we should just note this possibility, and to continue with our discussion on private nuisance, assume that both disturbances have interfered with Zach's work. However, before such interference can amount to an actionable private nuisance, it must also be considered as unreasonable interference. For point 2, we will endeavor to discuss what amounts to unreasonable interference and apply the facts of the case to determine if nuisance is actionable. Unreasonableness is something much more difficult to establish, as it is quite subjective and a lot of factors must be taken into account. The balance of what is reasonable and what is not reasonable is essentially an act of giving and taking, i.e., reasonable tolerance. It is generally understood that only interference which goes beyond the normal bounds of acceptable behavior will be unreasonable. Therefore, with this in mind, a few relevant factors should be taken into account, i.e., sensitivity, locality, duration, and damage. For point 2, we will first consider sensitivity and locality. For sensitivity, the defendant is not responsible for damage which occurs solely because the claimant or the claimant's situation is abnormally sensitive. This is applicable to the fact that both the recording equipment and the internet signal could possibly be abnormally sensitive in their own right. This is something which ABC Rail needs to prove before it can get away from being sued for private nuisance. For locality, where the interference takes place will also be relevant consideration in finding the existence of nuisance. Residents of any locality are generally expected to put up with the level of discomfort common to the area in which they are situated. This would mean that the degree of reasonableness and unreasonableness of interference would be different in different localities. For example, whether it be industrialized or residential areas. As the facts did not state the kind of locality we are dealing with, other than the fact that Zach's home is next to a railway line, we cannot comment much on this. But what is certain is that there is a recent replacement of railway track and installation of electrical power lines to allow the use of high-speed trains. This could mean that there is a sanctioned change in the locality. This is whereby the character of the locality may change upon a planning permission granted by the local authority. If there is a significant and legalized change in the characteristics of the locality, what might have amounted to a nuisance before the change could now be considered reasonable. The facts are silent on whether or not ABC Rail has been granted the permission by the authorities to replace the railway track and install the electrical power lines. However, it is possible to assume that they have been granted the permission to do so, otherwise they wouldn't have gone on with the upgrade. Despite that understanding, it should also be noted that planning permission alone will not by itself provide immunity if it does not effectively make an unreasonable interference reasonable. For point 3, we will now consider the last two factors to determine unreasonableness, i.e., duration and damage. Whether or not an interference is considered as a nuisance would depend on how long and how often the interference occurs. Generally, the longer the interference goes on, the more likely it is to be considered unreasonable. However, it should also be understood that the duration is again a very subjective requirement for which the wisdom of judges is required to determine the plausibility of nuisance. Applying this understanding into the facts, we do not know exactly how long this interference has been going on, but we do know that it was recent and it is probably long enough and frequent enough for Zach to no longer be able to use his recording studio during the day as well as his deteriorating internet signal. And this may be enough to satisfy the duration factor. Lastly is damage. Damage is more likely to establish private nuisance if the unreasonable interference actually causes physical damage to the claimant. However, it should also be noted that some form of discomfort or inconvenience is also enough to amount to damage depending on the circumstances of the case. Based on the facts of the case, it should also be easily established since Zach can no longer make use of his recording studio or internet properly. It could be assumed that he uses these two things for work, and if that is the case, then damage has been suffered by Zach due to what ABC Rail has done. Therefore, after going through the relevant factors to determine the unreasonableness of the interference, it is now possible for Zach to sue for private nuisance, and it is up to ABC Rail to bring up any defenses that can help his case against Zach's claim. In point 4, we will be discussing the possibility of a defense for ABC Rail and remedies for Zach. This is, of course, assuming that nuisance has been established against ABC Rail earlier. Generally, there are two defenses that defendants can go for against a nuisance claim. They are the defense of statutory authority and the defense of prescription. Under the defense of statutory authority, there will be no liability when a statute treats an activity as having authorized the nuisance, while under the defense of prescription, a defendant may have been prescribed or acquired a right to commit a private nuisance when it can be shown that the nuisance has been actionable for at least 20 years and that the claimant was aware of this during the relevant period. Based on the facts of the scenario, it is more likely that statutory authority would be a more relevant defense here compared to prescription. This is because, as mentioned earlier, it is likely that the replacement of the railway tracks and electrical power lines are authorized by the authorities. Also, there is nothing within the facts to suggest that Zach actually waited for 20 years before taking any action. With that in mind, we should now consider how the defense of statutory authority works and whether or not it can actually help ABC Rail against the claim. One thing to note is that a defense can only be inferred from the statute if it was an inevitable consequence that arose from its ordinary working, i.e., whether the nuisance can be avoided by the use of reasonable care and skill. Planning authorities would usually only have authorized a change in the character of a neighborhood, not authorizing an actual nuisance. This would mean that whether such a change had taken place would be a question of fact and degree, and this has to be balanced out together with the consideration of public interest. For now, it would be hard to say if any of the points raised for defense are valid, but that doesn't necessarily mean that Zach would be left without a claim. This is because as much as statutes can authorize an activity that inevitably causes a nuisance, it will also be able to compensate victims of said nuisance. There are statutes which provide self-contained systems for dealing with a failure to abide by their requirements, thereby allowing claimants to use those systems rather than suing in nuisance instead. This would mean that though the claim against ABC Rail directly might fail, it is still possible for Zach to get some compensation from the government for causing him not being able to use his recording equipment properly as well as his deteriorating internet signal. This is, of course, assuming that the statute which authorized ABC Rail to replace the railway track and install the electrical power lines also provides compensation for those who have been negatively affected by the activity. As always, a simple conclusion will do. We should definitely not insert any more new points into our conclusion, otherwise it wouldn't be a conclusion. Just briefly summarize what has been discussed in the content of the essay and highlight some of the more important points of the essay that may address the question. A conclusion for this particular question should highlight some of the key aspects of the discussion, such as why Zach may or may not have a case against ABC Rail. It should also be noted that since the question doesn't specifically ask us to advise any one party, or that based on our discussion there seems to be no clear conclusion, the above discussion itself is more important than any conclusive conclusion for this essay answer.